Welcome to tonight's webinar, the second in a series of legal talks by AOPA's Pilot Protection Services. Tonight's talk is about the FAA's compliance philosophy. We're now 2 years into this program, and we'll be reflecting on how things are going and talking about some possible room for improvement and other observations. I'm Chad Mayer, an attorney with AOPA's Legal Services Plan. And I'd like to introduce our panelists before we get started. To my right is Jared Allen, our senior attorney here at the plan.
Hey, good evening, Chad. Pleasure to be here.
Thanks, Jared. Appreciate you being here. To my left is Jeff Smith, team member for FAA's Compliance Philosophy Focus Team.
Thanks, Chad. Also a pleasure to be here.
Thanks very much for coming up. We appreciate it. As we alluded to, we're going to be covering a multitude of topics ranging from how the compliance philosophy works with some real-world examples, how well it's working, whether there's any room for improvement, as well as what recommendations the Legal Services Plan has for airmen who may be dealing with the compliance philosophy. Keep in mind you can subscribe to AOPA's YouTube channel with the red button, and you can call in with questions, 1-800-USA-AOPA, Monday through Friday, 8:30 a.m. to 6 p.m. Eastern Time. And if there's any questions for Jeff Smith, you can call our office and we'll make sure they get routed to him. Let's kick things off tonight with Jeff Smith. He's brought us a lot of great data on how the FAA is actually implementing the compliance philosophy, but first he's going to share with us some of the background. Where did the compliance philosophy come from and what's behind that? Jeff, fill us in, please.
Yeah, thanks, Chad. And the compliance philosophy is part of the FAA's risk-based decision-making strategic initiative. That's one of the strategic initiatives that guides the FAA as it conducts its oversight duties in ensuring safety in the national airspace system. And the risk-based decision-making, put simply, compels us to use safety information in order to make better decisions. So in terms of the compliance philosophy, it is getting information about a particular event and then using that information to determine the best course of action to correct it. And the compliance philosophy was signed by an order that was signed by Administrator Huerta in the summer of 2015.
And so, Jeff, what does that mean as far as the practical impact on airmen and other certificated entities who might find themselves the subject of an FAA investigation or a possible regulatory deviation or violation?
Yeah, and that's a great question. So what a person can expect is an FAA inspector to work with them, ask them questions to try to understand the specifics of the event, again, to try to come up with the best corrective action. And where able, the FAA will use non-enforcement or non-punitive measures in order to respond to a regulatory deviation. And we call those non-enforcement responses compliance actions.
All right, and Jeff, you brought us some great data hot off the presses, including fiscal year 2017. We have those numbers already. Let's take a look and you can walk them through us, please.
Okay, sounds good. And we'll see on there that we have legal and administrative, and those are both types of enforcement actions, informal and compliance actions. And the data that we have for fiscal year 15, we can consider that to be a pre-compliance philosophy implementation, and the FY16 and FY17 numbers being what we've seen post compliance philosophy implementation. And you can see the high number of legal and administrative actions for FY15. Now, the informal actions that are there, those were responses that the FAA had, but were part of the legal enforcement process. But then moving into FY16 and 17 with the implementation of the compliance philosophy, you can see that compliance actions, those non-enforcement responses, being used to correct regulatory deviations predominantly. And you'll note the drop in the legal and administrative actions.
Yeah, quite a precipitous drop there. And looking back at that data, it looks like enforcement actions have tapered off and stabilized. Administrative actions still trending downward, and then compliance actions obviously trending upwards. Do you see that trend continuing?
I do, and the numbers for FY17 are probably more telling, because in FY16, at the beginning of that fiscal year, we were just getting rolling with the compliance philosophy, so things were still being worked out, but certainly I expect the numbers that we see in FY17 to continue.
All right, thanks, Jeff, for walking us through that. We've also got some flight standards metrics for fiscal year 17, and let's take a look at those if we could.
Yeah, great.
Yeah. We see here that the average time to complete a compliance action is around 4 weeks. How does that compare to how long things used to take?
Well, that's a lot shorter than what we saw with enforcement actions. And one of the goals of the compliance philosophy is to resolve safety issues as soon as possible. So we want to have the corrective action as close to the event as possible, just to mitigate any ongoing risks that might be present. So the 4-week time is, again, very good in comparison to what we saw with enforcement actions, which for individuals might have taken months, or for larger organizations might have taken years. And with the compliance philosophy and compliance actions, one of the options is an on-the-spot correction. So that might be something that is addressed that day. We might also see education, counseling, remedial training, which might take a little bit longer. And for the organizations, we might see changes to manuals that might require a little bit longer time frame. But when you average all that out, we're around 4 weeks. And you can see on the other bullet there, FY17, 80% of regulatory issues are corrected with a compliance action, and that matches with the numbers that we saw on the previous slide. And even when enforcement is necessary, those enforcement actions that have been initiated since the compliance philosophy was implemented, as an agency, we're resolving those faster than we did with previous enforcement actions prior to the compliance philosophy.
Interesting, yeah. And in terms of those enforcement actions being resolved more quickly, Jared and I have noticed an uptick in emergency cases when enforcement does appear to be warranted in the FAA's eyes. I've often wondered if that's a result of more resources being available because of the compliance philosophy. Do you have any idea what's behind that?
Well, sure, and that is a great question. And one of the goals of the compliance philosophy, or another goal of the compliance philosophy, is to be able to apply the necessary resources to an enforcement action when enforcement has to be taken. There are times where enforcement is necessary, and in those times, the FAA wants to be able to take the action that's necessary, and we want to be able to apply the resources. And the compliance philosophy and the use of the compliance actions allows us to do that.
Understood. Thank you, Jeff. Let's move on to Jared Allen. He's going to discuss some of our experiences here at the Legal Services Plan, including our call volume, what types of matters we're seeing, and how often the compliance philosophy is applied. Jared, walk us through it, please.
Yeah, thank you, Chad. Well, first and foremost, I'm pleased to say that the information that we've collected here through our work at the Legal Services Plan reflects the same types of trends and results that Jeff was just talking about. And so we have a slide here, and this shows the Legal Services Plan's total call volume through the year of 2016. Now, this is significant because this was our first full year dealing with the FAA's compliance philosophy. And about of the 3,800 some cases that we handled here that were new matters, about 40% of those involved either compliance or FAR enforcement, things of that nature. Now, the majority of those cases that did involve regulatory compliance issues were resolved through the compliance philosophy rather than a legal enforcement or an administrative action. Now, as Chad has already mentioned and Jeff's mentioned, those enforcement cases that we did see typically tended to be those that involved very severe issues such as intentional falsification of medical applications. They could be other lack of qualification issues, intentional acts, things of that nature. And thankfully, we don't see a lot of airmen being the subject of those types of investigations. But for the matters that should fall within the scope of the compliance philosophy, we are seeing them in fact be resolved under the compliance philosophy, which is a very nice thing to see because it has a lot of benefits for the airmen, which we'll certainly talk about as we move forward here. And so far in 2017, we've already had here at the Legal Services Plan about a 16% increase in call volume. So even though we're already here almost the middle of November of 2017, we've got about 4,400 calls this year, and still the trend is continuing in that matters that should be resolved with the compliance philosophy are in fact being resolved with compliance actions, which is great to see.
Certainly. So that's 16% over last year, which was already an increase over the year before.
Absolutely.
So yeah, these inspectors are busy, but they are using the compliance philosophy well as far as we can see. All right, well, we'll be right back with you after a short break sponsored by AOPA's Pilot Protection Services. Remember, you can call in during regular business hours on the East Coast with any questions.
I was going to use the plane for business purposes. When I was dealing with Pilot Protection Services and I knew I had an attorney on the phone, it was one thing. But when I knew I had an attorney and a CPA, it was another thing. The gentleman walked me through the legalities and the accounting ramifications of all three types of companies that this airplane would be in, whether it was private, in my company, or in a new LLC.
Welcome back from the break. We're now going to delve into some real-world examples where the compliance philosophy has made a difference, and we'll be starting with Jeff. Now, Jeff, as someone on the Focus team, what instances come to mind where the compliance philosophy has made a difference?
Well, one instance that we see a lot involves pilot deviations, which could be anything from airspace incursions, inadvertently flying into a temporary flight restriction, or even a runway incursion. And we're seeing a lot of those types of pilot deviations being handled through the compliance philosophy. Just by their very nature, a lot of those pilot deviations are inadvertent, and thus they really meet the criteria for us taking a compliance action as opposed to an enforcement action.
All right, that makes sense. And Jared, you've counseled hundreds of airmen by now related to compliance investigations. What examples are noteworthy to you?
Certainly. So I would agree with Jeff in that one of the most common things we see are the pilot deviation cases where, whether it's an airspace issue, runway incursion, an airman who, for example, may fail to maintain radio communication on an instrument flight, as long as it is a unintentional, simple mistake that is either due to a misunderstanding of what's required or is just a boneheaded move, quite frankly. We are seeing those airmen, rather than being subjected to the legal enforcement process, being put through the compliance philosophy process, and typically those events are resolved with nothing more than counseling from the inspector, some education in the form of a wings course, for example, or if the circumstances require it, actual instruction from a flight or ground instructor. But overall, absolutely, when it comes to those pilot deviations, as long as it's not an intentional act, we are seeing them resolved through the compliance philosophy.
All right, great examples. Thank you. And
I was just going to add to that, if I can, Chad.
Please.
One of the things that we're seeing with those is the use of electronic flight bags and flight devices, and I'm not getting the right updates, especially on the temporary flight restrictions, and those being inadvertently entered into. So one recommendation I would have is everyone to call 1-800-WX-BRIEF, get that briefing. Ask for adverse conditions, which can be a abbreviated briefing, just getting the significant weather as well as any flight restrictions that might be in the area.
Absolutely, and that's excellent advice. And another common reason we always advise airmen to call that 1-800-WX-BRIEF number is that you are going to get, obviously, some very thorough information. Most importantly, TFRs. And we still see an issue with that, with some airmen not being aware that there's TFRs in the area. So it's always a good idea to call that number. And also, there is then an official record of you performing at least a certain extent of pre-flight planning prior to your flight. So excellent advice.
Certainly, I would echo that. Definitely excellent advice. I actually had saved myself from a pilot deviation recently. I had planned a cross-country trip, been planning it for days, just needed to update the weather and actually follow the flight plan. Turns out the runway was closed for repainting, and that was not posted very far in advance, but I found out before I took off, and that's what counts. So let's move on to a discussion of what happens with accidents or incidents, and where's the line? Where does a compliance action end? Where do you start looking at a 709 reexamination, or even something like an administrative action or an enforcement action? How do these pieces fit together?
That's a great question, and one of the things that brings up is another tenet of the compliance philosophy, which is really focusing on the underlying behaviors as opposed to the outcome. So if you have something like an accident, it's very natural to think, oh my gosh, there was an accident, really bad outcome. This is going to require a very strong reaction from the FAA. And if we have a situation where there's not an accident, let's say, and our reaction might be, well, it wasn't that big of a deal, so we don't really need to do much with it. But in reality, what we've got to focus on is the underlying behaviors and the choices that led up to that event, be it with a good outcome, be it with a bad outcome. And we want to take a look at those. And that also speaks to the willingness and the ability of a person to make the necessary changes to not only come into compliance, but also remain in compliance.
Sure. So I have a question for you about that one, because this is something that we see fairly commonly, and that is situations that don't necessarily involve an operational issue, but let's say an airman forgets that he has to go and do his flight review. And so he may not have a current flight review, or even in some cases where they are outside the currency date for their medical certificate. And so can you speak a little bit about how in those situations an inspector may talk to that airman?
Sure, and a lot of times we'll see those currency issues come up, or they're discovered during an investigation for something else. So, for instance, an accident or a pilot deviation, or even on a ramp check. And it's noted that the person was operating either without, like you mentioned, a current flight review or a current medical certificate. And in those cases, again, if it's inadvertent and the person is willing to get themselves up to speed either through obtaining that flight review or obtaining that medical certificate, then certainly a compliance action could be appropriate, and we see those in a lot of instances where that particular part of the investigation is dealt with a compliance action. Where we see the currency issues getting more towards the enforcement is when they're fairly egregious. So, a person has been outside of their flight review, say, for 10 years.
I was just going to say, I think we have seen that situation, unfortunately. So it's very hard in those circumstances for anyone to believe that an airman just inadvertently failed to comply with that flight review requirement. So certainly I would agree we see that as well.
We do, and of course we also know that there's a difference between perhaps inadvertently letting a medical certificate lapse when an airman is medically qualified and can get a new one, and the situation where the airman is not medically qualified and cannot pursue any sort of medical qualifications.
Absolutely, and that gets us into the intentional acts, which gets us into the enforcement response.
Gotcha. All right, and so we've talked about a lot of these things here, including enforcement. Obviously we know administrative actions are declining, and you think that they will continue to do so. Where do you see those being used, since they're still a part of the system? Mm-hmm. Yeah, what's an example of something where an airman might expect that? Because we certainly don't see as many of them as we used to.
So we might see an administrative action, and for an individual that would be in the form of a warning letter. Okay, where we believe that they're going to make the necessary corrective actions, but they might not be doing it in a timely manner, in a manner that's reasonable. Or it seems based on the case that we do need to get something official on that person's record, perhaps in terms of an escalating response. And going back to the pilot deviations, those types of infractions are actually the ones that we see the most repeat of. Okay, so recidivism, a person who's maybe committed a pilot deviation, there's a potential that they're going to commit another pilot deviation. That's the type of repeat issues that we've seen. And with those, we might have an escalating response from the FAA. So whereas we try a compliance action the first time, and with the hopes that it gets the person back into compliance and seems to do so, the person has another pilot deviation, short time afterward, near future. So now it's time maybe to up the response a little bit.
But now that's not necessarily going to mean that that case goes directly to enforcement just because they've gone through the compliance process once, correct?
Oh, that's correct. And in fact, even with a pilot deviation or any repeat issue, it may still remain as a compliance action. What the guidance calls an inspector to do is take a look at the root cause of that particular event. And perhaps the person attempted the compliance action before and it was successful, but it didn't get at the root cause. So that's not going to mean that the FAA is going to take enforcement action on the next time. We might take another compliance action if it seems like we didn't address the root cause the first time. However, if it seems like the person is becoming unwilling or unable to make the corrective actions to stay in compliance, then we might escalate our response with an administrative action or enforcement action, depending on the particulars of the case.
Yeah, good information about the root cause. Thank you, Jeff. And Jared, I wanted to ask you, what happens when you see flight instructors involved in compliance actions, either that the flight instructor himself is the subject of a compliance action, or perhaps it was a solo student, supervised solo, and perhaps the FAA wants to speak with both the CFI and the actual student pilot who had the deviation?
Certainly. So in those cases involving flight instructors, it really may be a situation that depends upon what was going on during that flight. So for example, if we have a situation where a CFI was providing instruction to a student and there was an operational deviation, the question may really come to be, well, was the flight instructor instructing a primary student who did not have their own ability to act as pilot in command, so the flight instructor is PIC? In those situations, we typically see the FAA focus their investigation primarily on that CFI who was the pilot in command during an instructional flight. Very seldomly do we see the FAA start to look at the student pilot who was on board that aircraft, whether they're a primary student or even an advanced student, for example, someone receiving instrument instruction. However, those situations can change if we've got, for example, a instrument pilot who may just decide to bring a flight instructor, CFII, along for the ride just to have another set of eyes and another set of ears. And in those situations, if that pilot, that instrument pilot, is acting as pilot in command, well, then it becomes more of a blurred line as to, is the FAA going to only be interested in what that instrument pilot has to say, or are they going to be asking what the CFI's role really was aboard that flight? And it can be a very gray area given the case law that's arisen over the years concerning the liability of a flight instructor on board an aircraft. So certainly, compliance action, we'll see it in those situations, but there are also some other situations involving flight instructors that can be a little more concerning. For example, we've seen a number of cases recently where a flight instructor has been providing instruction to primary students and perhaps has even endorsed those students to solo. And as the date comes closer and closer for that student's examination, the instructor finds that this student never actually applied for and received a student pilot certificate or perhaps a medical certificate. And there you've got an issue for both the CFI and the student, because there is a major question there concerning those, at least that student's qualifications to fly and the instructor's competence as well. So I don't know if Jeff has anything he can share with us about what he sees in those situations, but it's certainly interesting.
Very interesting, Jared. And certainly it does seem like, since inadvertent on the part of both the flight instructor and the student, it would be within the scope of compliance. But what are your thoughts on it, Jeff?
Yeah, that's correct. And what we've seen is in a lot of those cases that has been resolved with a compliance action. And just with any type of regulatory issue, the main thing is stop the non-compliance. So in the case that you just described, we would expect the student pilot not to solo until they obtain the correct certificate that can then be utilized for those solo privileges.
Right, certainly. That makes sense. All right, and speaking of flight instructors, let's move on to a discussion of how CFIs are important in the compliance philosophy in general, both to promote safe flying and regulatory compliance. Jeff, walk us through how you view the flight instructor's role as it relates relates to the compliance philosophy, please.
Well, sure, and the flight instructor has a very important role. And going back, if I may, to the situation with the student pilot, what we've seen is cases where a student pilot, say, has committed a pilot deviation, runway incursion, and how does the FAA interact with that flight instructor? And normally the FAA will contact the flight instructor, have a conversation with that individual. One, just to make them aware of the situation. Hey, your student, was on a solo flight and had this issue. Were you aware of it? And there might be some questions back and forth with the flight instructor, and there may be instances where the inspector asks to see the logbook of the student, and they're looking to see if the instructor made all the appropriate endorsements, if it appears that the instructor provided the correct training. Might also try to ascertain that through interviews with the student pilot as well as the instructor as well. And in a lot of cases, it's a compliance action that ends up resolving it. The student pilot says, "Yep, my instructor taught me that, but I just messed up. I just made a mistake." Okay, we can resolve that with a compliance action just for the student. It might be an instance where it doesn't appear that the flight instructor was negligent, but maybe didn't document something right, or maybe didn't cover something the way they should have in terms of the person's training prior to making that solo flight. In that case, we might have a compliance action with the flight instructor as well. And then, of course, in the rare cases, the investigation might reveal that the instructor really did not provide the degree of care that they needed to in giving that person instruction. And so we might be looking at a stronger response from the FAA, perhaps an enforcement action, or if we're concerned about the instructor's competency, might result in a 44-709 re-examination for that flight instructor. So there's a few things that can come out of those kind of situations.
All right, thanks for walking us through that, Jeff. And just wondered if you could talk a little more about the instructor's role in instilling a just safety culture, because I've always thought it's easier to teach regulations than it is to teach good judgment. So flight instructors are obviously key here.
Well, absolutely. And one thing that instructors can do is use the regulations as teaching moments for risk controls. And really that's what the regulations are designed to do. They're designed to control for certain risks. So by the instructor working with the student, going through the regulations that are pertinent for their flight and thinking about what hazards, what risks are these regulations attempting to address, and how are we going to ensure that we mitigate those risks or eliminate them, and how do we do that in staying within the confines of the regulation itself. So the CFI has a good opportunity to do that with their students. And then just in general, CFIs can play a very powerful role. Most of our regulatory adherence is voluntary. Okay, so when a person is making a flight, the FAA is not there watching over them. Okay, so the compliance philosophy understands that the majority of regulatory compliance is, in that regard, voluntary, and the flight instructor can do a good job in setting the foundation for their students, showing them, hey, we need to do everything right every time we go out. And so then the student will have that as they continue along with their career in flying. And the instructor can also show the student how important it is to keep up with the latest trends going in general aviation, and can share with the student what they do in order to keep current. Of course, AOPA puts out a lot of great material that can keep flight instructors and all pilots really up to speed on current trends. The FAA does as well. So the flight instructor can show the student that and really instill that in the students from an early point in the student's career.
Thanks, Jeff. Yeah, certainly tremendous importance, the role of the CFI, and as you mentioned, beyond just students as they advance onto whatever else they're doing. If a pilot's not pursuing any other certificates or ratings beyond private and maybe instrument, he's certainly never going to have contact with anyone from the FAA unless something goes wrong. He may only see a flight instructor every 24 calendar months for a flight review, so that influence is really critical, sometimes the only safety window in to reach that airman.
That's correct.
Yeah. All right, and let's move on to a discussion about safety management. And Jeff, walk us through that if you would, please.
Sure. So this kind of feeds into what we were just talking about in terms of the flight instructor kind of instilling good habits for their students. And we have the safety management flow chart there. So just kind of working through that. The first step there, top left, consider the operation and the situation. Okay, what are we doing with this particular flight here? Identify hazards and analyze risk. And you can do that in terms of looking at the regulations and looking at other safety standards that are pertinent to that flight. One of the examples that I've used before is the VFR weather minimums, and considering those weather minimums on a cross-country flight. And what's the purpose of those weather minimums? Well, one is to make sure that you can see so that you avoid other traffic, okay? And so that is something that the CFI can discuss with their student before going on that cross-country flight.
Right.
And how are we going to continuously adhere to that regulation? Is it we're going to get a proper pre-flight briefing, we're going to check ATIS or AWOS for airports along our route, we're going to use the traffic alert system that's on our aircraft, all of these things to try to deal with the hazards that regulation intends to address. Assessing risk, also part of that in the developing of the controls. So adherence to the regulation is the primary way that one can develop controls to control for the risk. Monitor and verify those controls. Are we still staying within compliance? Are we still maintaining those safety standards? And then monitoring for new hazards. Now that may seem kind of complex, but we really do that all the time, when we fly. It's probably in our subconscious just to do that. And for routine flights, I would say that we're just going to do this naturally. It's when we do something that's outside of our normal routine that we might want to make sure that we're systematically going through the risks associated with the flight, making sure that we're addressing them. And this can be through simple things such as checklists, acronyms, mnemonics, the I'm safe, the PAVE, that sort of thing.
Absolutely.
Just to double check and make sure that we're covering everything that we need to. And by instilling good safety management principles, using those risk assessments, thinking about the regulations, and not just are we going to comply, but how do we comply with them? I want to make sure for the people that have flown with a lapsed flight review, for instance.
Yeah.
They found that. What are they going to do to prevent that recurrence? Well, obviously they're going to get another flight review. But what about in the future? What are they going to do? It might be as simple as printing out a sheet that has all of their currency requirements, and they leave that in the aircraft, or they just have that in their flight bag. Every time they fly, pull it out. Do I have everything I need currency-wise? Sure. And then when they update that, get a new flight review, update the piece of paper. Same thing with the maintenance. So, we can do these kind of things in very simple ways. It doesn't have to involve complex systems that we might have for, say, a large air carrier. Even the individual can really adopt good safety management principles.
Yep, we can all be working harder every day on that front. Thanks, Jeff. Appreciate that discussion. We'll be right back with you after a short break, sponsored by AOPA's Pilot Protection Services. Remember that you can call in with questions during regular business hours on the East Coast.
I'd had a cardiac event in 2000, and when I called AOPA Pilot Protection Services and talked to medical, the lady there, Mary Ann, was just fantastic. I sent the information I had. She emailed me back a 3-page thing showing me, she prepared me for everything that I had to do. And I went down and I got through it. I couldn't believe it, I was thrilled.
Welcome back from the break. We're now going on to some of our own legal services plan observations about FAA investigations in the context of the compliance philosophy. Jared, what stands out to you about how these investigations are handled?
Sure, Chad. So, as we've talked about, the legal services plan handles hundreds of cases or matters involving the FAA's compliance philosophy every year. So, we've been able to observe a couple of trends, and these points aren't necessarily frequent issues, but they are points that are really warranting some discussion, because if you're the airman involved in the matter, it's going to have possibly a very significant impact on your rights and how that matter is resolved. So, concerning most of the pilot deviation cases that we handle here at the Legal Services Plan, we typically see the investigating FAA inspector initially contact that airman by telephone. And the most frequent way that the inspector gets the airman's telephone number is when the airman is advised by ATC of a possible pilot deviation and asked to call ATC when they land. That pilot then calls ATC, which is not something that's required, but many airmen, because they want to be compliant, do so. And when the airman calls that number, they're asked to identify themselves, their name, their airman certificate number, and their telephone number. And that recording of that phone call is something that's put together in the materials that ATC will eventually provide to the FAA inspector. And so when the inspector gets that material, calls the number, and he's now speaking to the airman. So under what's called the Pilot's Bill of Rights, it's a federal law that creates certain rights for pilots. That law requires that when an airman is the subject of an FAA investigation, that the FAA advise the airman that they have certain rights. For example, that they're not required to talk to the FAA, that the information they provide could possibly be used against them, and that they, for example, are able to obtain air traffic data concerning the event. So, for example, radar recordings, ATC recordings, information that could serve as evidence if the FAA were to pursue an actual legal enforcement action. The FAA has created what's called a Compliance Philosophy and Pilot's Bill of Rights brochure, and that document is what the FAA provides to the airmen, in writing of course, to inform the airmen of their rights as required under the federal law. So when we have situations where the inspector has contacted an airman on the telephone, the initial point of contact after a possible deviation, sometimes we see the inspector immediately start asking the airman to start providing substantive information about the flight itself before they actually send this airman this Pilot's Bill of Rights brochure. Typically, we'll see the inspector first ask the airman for an email address, and they'll send the Pilot's Bill of Rights notification electronically and say, once you get this document, review it, and then give me a call back, and we can start to go through this process. Some inspectors still like to send it in writing, and they'll ask that you sign a document that simply says that you received the Pilot's Bill of Rights brochure before you call them back. But in some cases, as I mentioned, the inspector is just immediately asking the airman to provide information without informing them that, hey, look, you don't have to speak to me, and if you want to get additional information, whether it's ATC or radar data, you have the right to do so. All you have to do is ask. So, Jeff, I don't know if you've got any thoughts on that, but we'd certainly be glad to hear them.
Yeah, thanks for that, Jared. And the reason why an inspector will go ahead and contact the airman as soon as possible after becoming aware of an event is to, one, eliminate any ongoing operational risks. So it might be a situation where the person didn't realize that they had perhaps committed an airspace incursion, but in any event, we want to make it known that there was a potential problem, so that the person can go ahead and start taking action on their own to address the situation. Also, we want the person to make note of any of their thoughts or collect any data relative to that flight or that event, so that they can better participate in the investigation process and better help with the root cause. In terms of the Compliance Philosophy and Pilot Bill of Rights brochure, just as you described it, the intent is for the inspector to contact the individual and say, I'd like to send you this brochure, either via email or through the mail, or perhaps in person. And as you noted, that gives them their rights and kind of explains the compliance philosophy and kind of talks them through it a little bit. And in instances where that does not happen, it would certainly be okay for the airman to ask, hey, is this a situation where I should be receiving the Pilot Bill of Rights notification? And in terms of either calling back air traffic control or immediately speaking with an inspector that contacts an individual and who might be asking those questions, it is certainly permissible and expected for the person to potentially obtain legal counsel first and get the assistance from you folks before engaging further with the FAA. And there is no penalty for that, really. We expect people to do that. We want them to be comfortable as part of the investigation process. We want them to fully participate in the investigation process, again, so we can get at what is really the safety issue so that we can correct it. And if that involves delaying callback to the inspector while they speak with an attorney, that's certainly within the guidance.
Okay. So, we talked a little bit there for about the Pilot's Bill of Rights and it creating the right that the airman can ask that inspector to provide the information about the flight, the air traffic data, whether it's the ATC recordings, the radar data, or investigatory documents related to the flight. Again, we typically see the inspector accommodate that request. Some inspectors are very proactive and will actually send it to the airman without even being asked to do so, and that's fantastic. But in some cases, we are seeing the inspectors say that, well, the airman needs to go to an FAA website to request it, or that they have to file a Freedom of Information Act request in some cases. Do you have any advice concerning airmen who find themselves in that situation where the inspector isn't willing to just send that information to them?
Sure, and I will note that the compliance philosophy and the PBR brochure, we offer that up front, even though the law only requires that it be offered if we think we're going down the route of enforcement. As a matter of policy, Flight Standards is offering that brochure at the first interaction, and that was based on feedback from individuals as well as advocacy groups like AOPA. So we responded by putting that policy into place. Now, if a person feels that they've made the appropriate request for the air traffic data to the investigating inspector and they're not getting the information that they want, then they can certainly ask the inspector. And I'm hoping that the situations that you've described will start to diminish. We've recently published guidance within Flight Standards that gives some updated procedures to the inspector on how to work with the air traffic organization, who are really the ones that collect and put that information on a SharePoint site so the inspector can get. We're hoping that that new guidance goes ahead and takes care of some of those problems that you mentioned.
Okay, great. So, speaking of that new guidance, another thing, again, not something we see too commonly, thankfully, is that an airman may get a phone call from an inspector who then asks that airman to provide some information within the next 24 hours or next 48 hours.
I've seen 12 even.
12 even. So, certainly, as we've mentioned, airmen typically do want to be compliant, they want to cooperate, sure. But at the same time, is there any expectation that they should really be sending that information and responding to a flight that may be weeks or in some cases even months ago within that short of a period of time?
12 hours seems to be a little tight, to be honest. And in those cases, I would say a couple of things. One is for the pilot to not be alarmed. Because the inspector is not going to be able to revoke that individual's certificate just simply because they didn't respond within 12 hours. Our enforcement, if it ends up going that route, has multiple layers to it: management review, our legal counsel review, that sort of thing. So I tell the airmen first, do not panic. Secondly, I would advise the airman to contact the inspector and say, hey, I wish to comply and I want to provide that information. I want to be a participant in this investigation and in figuring out what the root cause of the safety issue is, but 12 hours just isn't enough. Can I have some more time? And provide to the inspector what the airman thinks will be a reasonable time frame for them to respond.
Okay. So, again, on this new guidance, one of the things that we typically advise airmen when they receive one of these phone calls is to be very polite, courteous to the inspector, convey to them that you're willing to cooperate and want to answer their questions, but to send those questions to the airman in writing via email, which is very convenient if that inspector is going to be emailing that Pilot's Bill of Rights brochure and compliance philosophy brochure anyway.
And possibly even the ATC data.
Possibly even the ATC data, absolutely. So it makes it more convenient for everyone. But as from a legal perspective, it's nice to have the questions from the FAA in writing, and then you're able to provide your responses in writing as well. So there's a nice written record of all the information. However, one of the things we've seen is when we ask the inspectors to provide their questions, we see a couple of different formats. In some cases, the inspector may have a Word document that they've created that has usually about 20 to 30 questions concerning the event, along with a request to provide a narrative statement about what happened. Some inspectors may just send a letter of investigation type letter that simply asks you to provide any information you believe is relevant. And some inspectors may send a document concerning an investigation that is internal to the FAA and typically for the inspector to fill out, but instead ask the airmen to fill out themselves, which can kind of be confusing given the wording of the form. But is there a consistent format that's required of the inspectors when they're seeking this information, or what is the guidance for the inspectors in this situation?
So we haven't put forward any specific formats to ask these kind of questions. We wanted the notification and the correspondence to be tailored to not only the event but also the relationship that the inspector might have with the person they're dealing with. I realize for individuals who have committed a pilot deviation, there may not be an existing relationship, but if it's a situation such as a pilot school, there may already be some correspondence methods that have already been established. So we didn't want to preclude those from being continued to be used with a compliance action. Now, in terms of the format for the questions, or something that looks like an internal FAA form, what the inspector is trying to do is gather all the information that's necessary in order to analyze the root cause of the issue. And at the same time, there are some internal forms that the FAA has that we need to fill out. And one of those internal forms might be the Flight Standards Inspector response back to the Air Traffic Organization. And what I would say that is, no matter what format those questions come in, if a person has any questions about those, to ask the inspector. Call them up or email them back. Hey, I want to fill this out. I want to answer your questions. I want to be a participant in the investigation, but there's just some points that I'm confused about. And there's no harm in asking those questions.
Certainly. Okay. Well, so talking about forms that the FAA uses, one thing I do want to note, and this falls more into the legal realm rather than FAA flight standards, but on the remedial training syllabus forms and offer letters sometimes that we've seen come from inspectors, those documents usually lay out what training is going to be required of an airman as a result of a alleged pilot deviation. It might be a few hours of ground instruction or flight instruction, but it is one of the corrective actions that the FAA is requiring airmen to take through this compliance philosophy process. One thing that all pilots should be aware of, though, is that if you receive these types of forms from the FAA, you do need to read them carefully, because on some of these forms, there may be a sentence that asks you to waive your rights under what's called the NTSB's stale complaint rule. And this is important because this rule prevents the FAA from pursuing action against alleged violations that the FAA knew about for more than 6 months. And so if you're an airman who's contacted about a possible pilot deviation, an investigation for something that occurred more than 6 months, maybe even a year ago, you do need to be very careful, because what you sign on those documents could have an impact on your legal rights when it comes to the FAA's ability to have a legal enforcement action. So really the takeaway there is make sure you read everything before you sign it. And if you have any questions, you can ask the inspector, but at that point I'd certainly recommend getting your own legal counsel as well.
Sounds like good advice, Jared. In your experience, are those waivers effective?
Well, that is a bit of an open question right now. I don't believe one of those waivers has actually been relied upon by the FAA in an NTSB, at least a reported case to date. I have not seen it, but certainly you don't want to be the airman who's the test case. So it's better to avoid the situation altogether.
Agreed. Thanks, Jared. Appreciate that. Jeff, did you have any thoughts on that before we move on to 61.15?
Yeah, and certainly on the stale complaint and just addressing matters, again, the FAA wants to do that as quickly as possible. We want the time between the event and the addressing the issue, whatever means that might be, to be as short as possible. So even on some things that might have happened months ago, we want to go ahead and notify the airmen, again, make sure that they were aware of it, and also make sure that the problem has been corrected. And a lot of times it would have already been if it's something that's happened well into the past. But the FAA, in order to keep with its obligations, is going to need to make sure that there is not an existing safety issue that's out there. And on the remedial training and the waiving of the stale complaint rule, of course, that's just so that the FAA can take action should the remedial training go longer than anticipated and the remedial training be unsuccessful. So the person drop out of it or is just unable to meet the training standards.
Understand. Well, one additional issue that I think would warrant some good discussion would be the issue of the requirements of FAR 61.15. Now, this regulation requires that airmen who have certain motor vehicle actions, like the suspension, revocation, or cancellation of your driver's license, or that relates to a driving under the influence charge or an arrest, operating while intoxicated, drug or alcohol-related arrests. It requires that those issues be reported to the FAA within 60 days. Also required to be reported are convictions, either federal or state, for statutes concerning drugs or alcohol. Now, we have seen the FAA respond to an airman's failure to notify the FAA within 60 days of these events, handled in different ways. So in some cases, we've seen the airman get a letter that says, well, you should have reported this, report it now, and make sure to comply with this regulation in the future. In some cases, we've seen a little bit more investigation occur. And in other cases, we've seen the FAA actually immediately start the process for legal enforcement action. And so I'm wondering if there is something out there that you're aware of that might address this situation as far as consistency from the FAA's perspective.
Well, in terms of addressing those issues, that's handled by the FAA's Office of Security and Hazardous Materials. So they have the interface with law enforcement. And so they're the ones that deal with those cases for 6115 and the failure to report those events that you described. And that office does have a list of criteria that they look at, and depending on the circumstances of the case, how long has the person had their pilot certificate? Is it a student pilot versus someone who has been active for 20 years? When did the violation, the motor vehicle violation, occur in relation to any applications that they might have put out? Does it seem to be inadvertent? Did it seem to be willful? Does this person have a history of that? That sort of thing all factors in, and then depending on those factors, that office will either respond with an education letter or, as you mentioned, perhaps administrative or even legal enforcement action.
All right, thanks, Jeff, for breaking that down for us. So now we've reviewed some of our observations from both inside the FAA and our vantage point here within the Legal Services Plan, and we're going to move on next to discuss our tips for airmen who may be faced with an FAA investigation that involves the compliance philosophy. Jared, what advice do you have for us?
Well, Chad, I would advise all airmen who think that there may be an issue with compliance, most commonly operational, of course, to continue to file reports through the NASA Aviation Safety Reporting System. We harp on this point a lot here at AOPA, but it still seems that we talk to a lot of airmen who aren't familiar with NASA reports and the benefits of those reports. And quite frankly, if you're able to file that report within 10 days of the event, as long as it is not deliberate and inadvertent, you are able to receive some protection in the event the FAA does pursue legal enforcement action as a result of the reported event. It is completely confidential. It is voluntary. The FAA does not see that information, so you don't have to be concerned about it triggering an investigation. But it's really just one of those great things you can do to try to make your situation a little bit better than it otherwise would be. So, certainly I'd encourage airmen to file those reports.
Certainly good advice, and I've heard from airmen who are under the misapprehension that one can only file such a report once every 5 years, whereas I encourage people to file early and often. And what advice would you have on that front?
Absolutely. There is a limitation on how often you can rely upon a report, and that's mean to actually use it to waive any sort of suspension of your pilot certificate as a result of an enforcement action. You can only take that advantage of that report once every 5 years. Now, when it comes to filing them, there's no limitation. You can file as many of these reports as you like, and as you know, we have some airmen who carry a stack around with them, and some even want to file one after every flight. And hopefully that's not required, but it's certainly not prohibited. So you can certainly do that if you'd like.
There you go.
And if I can, add one other thing, I think
Please.
that those are great points in terms of the legal protections that program offers. But I'd also note too the safety aspects of the NASA reports and being able to get information into the system. Those reports are looked at by NASA. They are scrubbed, so they're de-identified, and trends are noted in there, and that information is sent over not only to the FAA so we can take the appropriate action, but is also used as a part of the information loop back out to the public. So that program puts out a regular publication that you can look at and kind of see some of the submissions that have been sent in or some of the trends. So it's another way that we can kind of work in that safety management loop. and that voluntary exchange of safety information. So the airmen, when they have an issue and they provide that report, they send that in, and then that ends up coming back around either in changes to guidance, or if nothing else, just information that can be used by the aviation public.
Great point, Jeff. Thank you. Yeah, not just for use in protecting pilots, but also adding to the conversation about safety of the national airspace system. All right, let's move on now to a discussion of Pilot's Bill of Rights and how important it is for airmen to understand what those rights entail.
No, certainly, Chad. I mean, as we've already discussed, I mean, the Pilot's Bill of Rights really does provide you as an airman a lot of nice rights, and really the most important there is being informed that you're not required to provide information to the FAA. Now, keep in mind that this compliance philosophy that we've been talking about, as Jeff has mentioned, does require that the airmen provide certain information. And so you do have to kind of balance how much information you are giving as a result of the situation to achieve the safety goals that the FAA has here. But you do need to be aware that when you're making statements, that information could be used against you if for some reason the event itself does result in enforcement action. And as Jeff mentioned, in certain situations, maybe an airman is unable to complete the remedial training or just decides they don't want to. In those situations, anything you've given the FAA to date through this compliance process could become part of an investigatory file. So it's just a matter of being familiar with the Pilot's Bill of Rights, not being concerned to tell that inspector, look, I'm not refusing to cooperate. I do want to give you this information, but let me have a minute. Let me talk to whoever I need to before I get back to you. And also, as we've talked about, feel free to request that information through the Pilot's Bill of Rights, the radar data, the air traffic data concerning a flight, or exercise your right to obtain counsel. These are for the airmen. It's a great law, and it's just something that you need to be truly aware of and take advantage of in order to really benefit from it. So I would certainly recommend that. And along the same lines, as we've mentioned before, it's my preference to ask for the questions in writing from the inspector and respond to them in writing, so you're not put on the spot talking over the phone. But that's just a recommendation. Certainly if someone's comfortable doing it otherwise, it's their discretion. But
I was just going to note there too, our guidance within flight standards compels the inspector to note whether or not enforcement is being pursued or whether something appears eligible for a compliance action. And that should be in the communications that are coming from the inspector. So if the airman or other individual or you all as legal counsel are concerned about which way does the FAA seem like it's going, then that question should be asked of the inspector, and they should be able to provide that.
Certainly, thank you, Jeff. And we've noticed it seems to be an improvement lately in terms of inspectors sharing whether they anticipate a matter will be resolved under the compliance philosophy. But our advice, as always, would be if there's any doubt, ask the inspector.
And I'll just note there that, from our perspective, I'm glad to say that we have seen most cases that start with a compliance approach be resolved with compliance. Very seldom do they actually go from a compliance action to a legal enforcement action. In the cases that do, I think you're typically looking at, for example, the event itself is not really the true issue. What happened after that event, as far as the investigation is concerned, revealed a lot more problems. And in many of those cases, for example, what started out as a altitude deviation has evolved into an investigation that discovers that perhaps that airman falsified some documents or just completely was ignoring the qualification or currency requirements. And then, since those matters require enforcement, everything requires enforcement. And so it's just, again, it's good to take a proactive approach about this from the very beginning concerning the investigation. And quite frankly, you can be even more proactive, and that is to try to avoid getting yourself in one of these situations altogether by always making sure that you're current and qualified, that your aircraft meets all of its requirements, whether it's airworthiness or just being properly maintained. I mean, it's much better to just do everything you can to fly safe and put yourself in the best position. And certainly mistakes happen, and that's what this compliance philosophy is there for, and we've seen it work.
Yeah, thanks.
And the compliance philosophy recognizes that most people are trying to adhere to the regulations and maintain safe operating practices as best they can. But like you mentioned, Jared, there are sometimes mistakes, and we want to deal with those. And in the majority of times, we can deal with them with a compliance action, as we saw from the numbers earlier. And that is the FAA's goal, is to deal with those situations that can be resolved with a compliance action by using a compliance action. Again, free up the resources for when enforcement is really needed. And there are some times where it is needed, where somebody is unwilling or unable, or has really gone beyond the reasonable care that's expected of them, and we have to take enforcement.
Sure. So one of the things I recommend to pilots who have found themselves the victim of a simple mistake, or whether it's a operational deviation, altitude, airspace, runway incursion, I will advise them that maybe in their best interest to go out and get some training on their own right off the bat. Mm-hmm. Try to put yourself in the best position possible to correct whatever may have contributed to this event. As an inspector, what would your reaction be to an airman who did that, who went out, who tried to fix this problem on their own, but nevertheless that's not going to prevent the FAA from investigating it? But are they going to be better off than an airman who did nothing at all other than wait for the phone call?
Yeah, absolutely. As we talked about before, with safety management principles, we want to be on guard for any ongoing operational risks. So what the FAA expects to see is a person take action to bring themselves back into compliance and then maintain compliance moving into the future. And so, whether there's an FAA investigation or not, or the person expects to get a phone call from the FAA, they should really be taking action as needed in order to make sure that they're going to continue operating safely. Now, in terms of an investigation and the compliance philosophy, the guidance does allow for an inspector to consider actions that an individual or even an organization has already taken. So, if a person has, using the pilot deviation again, has a deviation and then it gets with their instructor and receives some ground, maybe some flight training, documents that, and by the time they get with the inspector, they can show, hey, I've gone ahead and taken action necessary to address the problem. That may be the end of the story there, and the inspector can use that training that the person gained, to resolve the issue and document that as the compliance action.
All right, thanks, Jeff. And yeah, I can certainly echo that that's not just how it works in theory. It is playing out that way. I think the both of us have heard from airmen who may have had, an airspace incursion or something along those lines, got with a flight instructor, was able to provide documentation to the FAA inspector that they got some training on airspace or whatever the case may be, and the inspector ends up saying, well, that's exactly what I was going to ask you to do, and you've done it, so thank you, and back in compliance. Jared, do you have anything else to add on our recommendations for airmen?
Well, when it comes to these events, as I've said in the past to airmen, obviously there's a lot going on in these situations, and no one wants to find themselves being the subject of an FAA investigation. But this FAA compliance philosophy has been a very significant departure from how the FAA responded to possible deviations or violations in the past. So there is hope. You're not going to lose your pilot certificate for most of those unintentional, simple mistakes. But that being said, you just still need to take certain precautions when it comes to these events.
All right. Well, thank you, Jared. Jeff, did you have any other closing thoughts before we wrap it up?
Kind of along those lines again, let's try to take action to keep ourselves in compliance with the regulations within other safety standards. And when deviations do occur, stop the deviation, address the problem. And that's just good principles, whether or not there's an FAA investigation that's going on as well.
All right, good advice. Well, thank you both for joining us. Thank you for watching this 2-year follow-up on the FAA's compliance philosophy. Remember that you can subscribe to AOPA's YouTube channel with the red button. With any questions for us, you can call into the Legal Service Plan, 800-USA-AOPA, 8:30 a.m. to 6 p.m. Eastern Time. It's option 3 for legal. 3 for medical, 4 for legal. You can also, if you have any questions for Jeff Smith, you can ask us and we will make sure that they make their way to him and get you back an answer. Thanks again for joining us. Have a good night.